Alex here with a high conflict child custody video on education. And actually, we could probably call this video a school dispute or education dispute. I don't know what I'll put in for the title, but the point is that two parents have different ideas as to what school their child should go to, and it's actually a very common dispute. And unfortunately, it doesn't oftentimes get in front of the court because most parents wait till the last minute to create this issue for the court. And I hate to use the word create, but in my opinion, it seems to me, and I've talked about this before, but there's this sort of Cold War approach with dealing with this issue. It's a very common problem where two parents don't want to talk about the school dispute. And both of them probably have it in their head that there's not going to be agreement on the school, but neither one wants to talk about it. Or they do talk about it and they don't litigate it, so they go back and forth and argue for like 5 months. And then at the last minute, it's not decided, and one parent enrolls a child in one school, and the other parent enrolls a child in the other school. And this is so common. And then they go to court and want to fight it out, and school starts like 2 weeks from now. Don't do this, please, guys. It drives the legal system insanely crazy, and it's because it happens so often. And it is their job to choose which school the child should go to, but when the parents wait till the last minute to bring it to the court's attention and then they try to treat it like an emergency, it just drives everyone nuts. So first thing, don't do that. Especially if you have a high conflict ex, if you have a high conflict ex, you can anticipate that this is going to be a problem. So send a message like 6 months prior to school and say, hey, I want the child to go to this school. And when they respond in a crazy manner, file your motion. If they don't respond to you at all, wait like 2 weeks and then file your motion. And that way, when it's before the court, you have your dispute on track to be resolved within the timeline of the court system, which is often several months long. Then you don't have to file an emergency this or an emergency that, because you have plenty of time for the court to decide it. And it sounds to me like if you do something 5 or 6 months in advance, you might even have enough time for an appellate court to intervene if they have to. In Nevada, we only have, I was going to say one case, but we really have two cases that talk about what happens when two parents can't agree on which school the child should go to. First of all, it's a legal custody issue. So if one parent has sole legal custody, they can just decide, and the other parent really doesn't have a say. Oftentimes in Nevada, parents have joint legal custody, and so both parents have a say. One of the cases talks about this in the sort of general sense, and it's Rivero 2009, and it basically states that when parents can't agree on an issue like this, then they come before the court on equal footing. That's the beginning of the end of it. It doesn't talk about anything specific to education. It just mentions education, sort of, just kind of glazes over it as an example of a legal custody dispute. The second thing, the second case actually came out much more recently, and that's I guess they pronounce it Arcella or Arcella. In Nevada, it's 2017 case, and this is going to be one of those things that's not going to be, I don't know if it's going to be very helpful to people in other states, because I have a feeling that stuff like this is probably going to be unique to each state. It's not really sort of, and I'm sure some states don't even have a case that goes this specific into the dispute as to which school the child should go to. But we have one now as of 2017, so I figured I would do a video on it. Maybe it helps people sort of get some abstract or maybe analogies as to what they can draw from with regards to their state and our Arcella decision, Arcella decision. This case kind of focuses heavily on a religious angle. There is this, I guess the judge decided to use the religion as something to base its decision on, and the U.S. Constitution forbids that. And so I guess it was the problem has to do with the 14th Amendment. Well, they have quite a few amendments that they mentioned in this case. You can read it for yourself if you'd like to, but they actually go over the first, 14th. I think there's another constitutional amendment that they go through, but there's a lot that has to do with what this court did wrong with regards to religion. And in Nevada, and I imagine since they're connecting this with the Constitution, this would apply to all 50 states, the court has to treat religion neutrally. And it's not just comparing one religion to the other, it's even comparing religion in general with atheism. I guess you could take the non-religious approach. The court has to make decisions that are based on the best interests of the child when dealing with which school the child should go to when two parents disagree. And that has to be based on non-religious factors between the school and not so much the label of that particular religion that's on the table. The other thing, at least when it came to Nevada, is the court actually has to hold an evidentiary hearing. This particular judge decided to just base their decision on what the parents were asserting in their briefs and decided to not hold an evidentiary hearing at all and just made a decision just like that, which is, this is another thing that frustrates me about this video, is that particular thing that I mentioned, that's not even specific to legal disputes in the first place. I mean, that's just a principle that applies to any type of custody issue that parents have in our courts. There has to be an evidentiary hearing when the court needs to make findings of fact as to allegations the parents are making. When there aren't any, which is rare in these types of cases, then yeah, they can make a decision without an evidentiary hearing or a trial. But most of the time in child custody cases, parties are accusing each other of things, facts are being alleged, and the court is going to need to make a final decision of some sort, and the only way that you could do that in Nevada is with an evidentiary hearing. So that particular thing that they went over in the Archella case isn't even really specific to what's going on here. And then the third thing that came up in this case had to do with making findings that are based on the best interest factors, which again is another one of those general things. I suppose that this case came out to just really underline the fact that the judges needed to connect this specific issue, choosing a school, to any other type of issue that the court needed to make a decision on. I suppose that our Supreme Court had to deal with this sort of problem several times, so they finally decided to publish a case on it to just really underline that. The only other thing that jumps out at me is the religious dispute between the parties and each other and the judge, of course. So the last thing that I wanted to mention to people is that it might seem like a pointless thing to go back to court for, but one of the things that I try to remind my viewers is your child's education is a big deal. And if your ex doesn't agree, and they're a high conflict ex, then they're most likely not agreeing just for the sake of not agreeing. So it's most likely not even a valid point that they're making. I mean, it's one thing if you are in a low conflict case and you feel your school is better, but the other school is also great, and the other parent has the child's best interest at heart. That's one thing for you to say, I'm not going to fight this, fine. We'll just go with their school just so we can avoid fighting. But when it comes to high conflict child custody cases, their arguments are often inane. And that's actually something that I went through in my case. And eventually we're going to get to this point in the My Docket series where you're going to actually see the hearing, because it went to a hearing. And I did end up winning that hearing. But yeah, in those particular situations, when your ex is trying to put your child into a terrible school just because they want to, just to spite you, yes, you need to fight that. And I'd like to let my viewers know that not every issue in court that goes to a hearing is one of those end of the world issues. Oftentimes when we're representing ourselves, especially, anytime we have to go to court, it feels like the end of the world is coming, because it's so terrifying and scary and you don't know what's going to happen. But fighting over which school the child should go to, while important, is nowhere near as I guess you could say impactful or scary as fighting over physical custody of the child, because that's going to impact pretty much everything with regards to you and your child's relationship, and it's also going to have a severe financial impact on you. But try to keep in mind that if you have to go to school for an issue like this, or if you have to go to court for an issue like this with regard, your child's schooling, it's not one of those things where you have to really, you don't have to go to court nervous that it's going to go outside of those boundaries. You're going to go to court on this specific issue. They're going to deal with which school your child should go to, and that's it. And it does suck to lose, but it's not the same as if you went to court and lost custody of your kids. It's not the same as if your visitation goes from every other weekend, from half the week, or every week on, week off, to and every other weekend. That those situations are much worse, and you have to kind of put these hearings into their own sort of category. You can't let your brain just kind of lump the court experience all into just one big giant scary blob. That's one of the things that I end up having to tell my viewers a lot, is I have to really tell them, you know what, sit back, look at this from afar. This dispute, it's scary to go to court, but it's a school dispute. It's not the end of the world if you lose. If it's worth it, fight it. Like, I get it if you have an attorney and it's going to cost you $10,000 or $20,000 to fight. That's a car you're throwing away. I understand that that's different, but if you're here representing yourself like I did, you're not going to lose any money for fighting. To have your child go to the best school possible. And I don't know what else I can say about this video. I did want to cover this topic quite a few times over the past year, and I just never got around to it. And I feel like now maybe I know why I never got around to it, because it's one of those thorny subjects. Anyway, I think I did the best that I could with this high conflict child custody video. I think you're going to end up learning probably a lot more from my hearing video when I actually put it on to my docket series. It is coming up. You're going to see me fight on this specific issue when it came to what school my son would go to. And I think it's going to help people a lot more to actually see how I approached it in court with the judge. When it comes to what the court is looking for under the best interest factors, typically they compare the school's records when it comes to academics, where they rank. It's not the easiest thing in the world to compare, though, because sometimes you have these apples and oranges comparisons, especially when private schools are involved, especially when charter schools are involved. I know that here, the local counties, or I've lived in Washoe and Clark County, and as far as I know, both Washoe and Clark County keep detailed records with regards to how the schools are ranked within the county, but they don't really include, like, for example, private schools. And I've heard before from people, even from teachers within the district, that the metrics that they apply to all of the schools are fudged a little bit when it comes to charter versus public schools. This is just something I've been told. I don't want people to take this and kind of run with it. I don't know if it's true or not, but what I was trying to say is sometimes comparing the schools is difficult. It's not so easy as, hey, just look at this spreadsheet, Your Honor. It's sometimes it's more nuanced. In my particular case, I know I mentioned my docket series in the video that was coming up. It was an article in the Washington Post, if I remember correctly, that I used that had I guess the Washington Post on their own ranked schools. I can't remember now. When we get to that video in my docket series, we'll talk about that a whole lot more. The other thing that I wanted to mention, well, two things that I wanted to mention, is one is money, and one is when the child is established in school. So we'll talk about the money first. Sometimes one of the parents wants to put the child in a private school, and they want the other parent to pay. That gets complicated. When two parents agree, that's one thing. The court typically isn't going to intervene because it's never going to go before the court. But when one parent admits, yeah, that private school is better, but I can't afford it, you never know what's going to happen. Sometimes the judge will say, okay, if you want to pay for the full amount, then yes, the child can go to the private school. And oftentimes that's one of the angles of a high conflict parent. They don't mind if they financially annihilate themselves if they can do the same thing to you. But once faced with the prospect of taking on the entire financial burden, all of a sudden, no, I changed my mind. Or they'll say, okay, that's not fair. I'm going to push really hard for you to force my ex to pay half. I might appeal it or something. The money angle does matter. And I know that a lot of people say, both parents should do what's best for their kids. The thing is, you have to kind of look at it from the perspective of what would you do if you guys were together. There's a lot of people who are in relationships together, and they don't put their kids in private school even if they can afford it, just because it's a lot of money that they could put towards other areas. And so sometimes when people split up, the attitude towards funding these things changes and becomes it's like when it comes to spending money on the kids, when people are together, there's more understanding that things aren't so simple as just put all the money that you possibly can into the kids. There's the relationship is going to need a certain amount of happiness, a certain amount of money has to be spent on the parents themselves. It can't just all go to the kids. But when people split up, all of a sudden it's almost I guess they have a word for this. It's demagoguery, where parents will use arguments that sound really sweet and popular, even though they don't really sincerely mean them, just because they want to get an edge or win. You can look up demagoguery. It's used in politics a lot, but it's like, oh, but the children, it's the children need, all these wonderful things, and we should spare no expense for them. Yeah, it's a really nice sounding argument, and it makes you look good to say it, but would you say that kind of stuff when you're together? Like when people split up, all of a sudden they start to really pull out all the stops when it comes to pushing for this stuff. The money angle does matter. Sometimes parents will agree and the child will be enrolled in a private school, and then one of the parents will say, hey, I can't afford this next year. And then it ends up in court anyway, and it's a problem. And just keep in mind that child support is kind of intended to cover all these things. And I know there's deviations, and I know that the court has discretion. I use the air quotes. I have a video on discretion, and people who've seen that know my opinion on it. All I wanted to say with that portion is that it does complicate things, and just because your school is better doesn't mean you're going to win if your school costs both parties $2,000 a month. It matters. The other thing, the last thing that I want to mention is the stability argument. Don't underestimate it. A stability argument is a strong argument, and it often works. So if you really want your child to get into a great school, start first grade, or try and do it at a junction grade. So like the first grade to middle school, or the first grade to high school. That's the time to really push for the better school. If you try and do it in the middle, like second, third, fourth grade, or in the middle of high school, the other parent will usually oppose on the grounds that their child is happy where they are and they've made all these friends. And I'm not going to try and belittle that argument. In fact, that argument is a really good argument. Children should learn how to establish social relationships. That's part of life. And so you may have a better school in mind, but the court might weigh those two things and decide, okay, your school is better, but the child is going to suffer if you tear them away from their friends. So I just wanted to remind people that is relevant. There's no real silver bullet to beating that argument. It's one of those things where you're kind of at the mercy of the court. Different judges have different opinions as to how much weight they want to give to each of those two things, and it's not one of those things that's very easily defeated. So I did want to mention the trying it at a threshold year or trying it straight away for kindergarten, first grade, whatever. And just so everyone knows, that's what I did. I fought hard at the kindergarten level because I knew if I didn't fight at that level, then my ex was going to raise as a shield the argument that he'd made a bunch of friends in his school. And she actually did try and do that a little bit under other, I think it was when I tried to successfully relocate it. I didn't just try, I succeeded. I think at this point we can go ahead and end this video, and I will see you guys next time.